Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Well, we're here today with Dale Galipo. And Dale and I have been knowing each other now for several years, and I believe we were introduced by our mutual friend, Brian Panish. Is that your memory, Dale?
Yes, it is. I think Brian gave you my phone number. You gave me a call, and I think you were surprised at how willing I was to help you and work with you.
Well, I'm always surprised because, I come with a lot of baggage. So when people are like, "Hey, I'm going to give you a shot," I always appreciate it. And so Dale and I did quite a few webinars throughout the pandemic, breaking down various results that he's had in different federal courts, going against the government, on these civil rights cases. And I learned a lot because I have a special place in my heart for those cases, being a criminal defense lawyer for 17 years back in Detroit, Michigan. But and Dale's actually you're from the Midwest too. Where is it, Cleveland?
Right. I'm from outside of Cleveland, Ohio.
All right. So Dale, well, now you're in California, but tell us, before we talk about your move to the West Coast, let's talk about when you knew that you wanted to be a lawyer.
Well, I wasn't sure. My dad was a lawyer. He was a personal injury lawyer, not a real trial lawyer, but a PI guy. So I think that left an impression on me. He drove nice cars and he dressed in nice suits. So I thought that was pretty cool. And I was proud that my father was a lawyer. And then watching lawyers on television, I got the impression in my mind they could really help people and they were respected, well-educated, and could make a lot of money. And all of that was appealing to me. I thought that would be something to think about doing.
And when did these epiphanies come to you that this might be the right role for you? Like, how old were you?
Well, over time, I went to the University of Michigan as an undergrad. I focused in business. I got a degree at their business school. I decided I want to go to law school. A couple things that were inspiring to me is my first law books that I got in business school. Real estate law, business law. I thought it was so amazing that I was taking a law class and learning the law. And then I would go study in the law library at the University of Michigan, which is pretty amazing. And so I just felt inspired. I wasn't really sure what I wanted to do. I never thought I was necessarily going to be a trial lawyer. I thought maybe corporate law or tax law. I wasn't really sure, but I thought, I think I should go to law school and then I'll figure it out from there.
Well, I think that's what a lot of us do. But before we talk about law school, I do want to compliment you on your decision to go to the University of Michigan, probably the greatest school in the country. The fact that I went there myself has no bearing on my opinion. I just wanted to say that for the record. I have no biases. And the move to California. So you graduate from the University of Michigan, but then you decide to go to school out on the West Coast. So tell us a little bit about that choice.
Right. Well, first of all, I must say, Dan, as you could imagine, being from Ohio, I did take a lot of flack going to the University of Michigan, where their arch rivals are the Ohio State Buckeyes. But I took the higher ground, and I do agree with you. It's a fabulous school, and I was very happy to go there. So I applied to a lot of law schools. Some I got in, some I didn't. A few I was on the wait list. And then I got accepted to UCLA. And of course, my parents didn't want me to go to UCLA. I was accepted to Georgetown and some other schools. But at 22 years old, never been west of Chicago, used to the cold winters in Cleveland and Michigan, I had visions of beaches, beautiful women. I'm going to California. So that was it. At 22 years old, I had a Malibu Classic. I had a small U-Haul, everything I owned, which wasn't much. And I drove across the country 4 days. And there I was in California. And boy, it was amazing.
Right. And, I think you had a brief time in a unique profession that I think well prepared you to be a trial lawyer. At least I've heard this, but I don't know if it's actually true or not. But is it true?
Well, yes, I don't want to get into too much details, but let's just say that
Let's just say the Dale in Chippendales is a reference to Mr. Galipo.
let's just say I was multi-talented young man and trying to find a way to earn some income in relatively short periods of time, even going to law school so I could study. And some people don't realize I graduated from law school in 1984. I didn't take the bar exam to 1989.
Really?
So for 5 years, I was doing everything other than practicing law and having a lot of fun, but perhaps a little too much fun. And then after 5 years, I had to say, okay, it's time to get serious. I'm going to study for the bar exam. Imagine 5 years later, starting to listen to Barbary tapes and read Barbary outlines. That was my path.
Oh, well, I can imagine it pretty clearly, Dale, because when I was, I think, 46 years old, I sat for the California bar 4 times. And so I know what it's like to sit and study while everybody else is out having fun and being like, past like a student's stage. But this is what we got to do if we want to have a license in California. You got to tackle that California bar. So
Yes, but I do think in some ways that was part of my comfort in front of people, having been in entertainment, having been a dancer, a professional MC for large events and shows. I do think having that stage presence helped me later on in the courtroom. I didn't really realize that it would at the time, but I do think it did.
I can only imagine what a great benefit it was because in these conversations I have with so many great trial lawyers, you know both in the case analysis on the webinars and on these podcasts, people are like, oh, there's some people got it, some people are naturals. I'm like, I don't think so. I've never seen somebody that was a natural. Now some people might start out a little further ahead because they have done some things, like let's if they were if they were stage actors, or if they were athletes in college and they're used to performing in front of large crowds and it doesn't affect them. That's a little bit of a head start. But that's all it is, a little bit of a head start. It's constantly doing the constant work, the daily work of getting better at our crafts every day, which helps people, to become the great ones. And because I do a fair amount of reading and research on, like, high performance. What all the research shows is that the people at the top of the game, the people that there's the ones that are really good, like let's say, I don't know, it's like Kevin Durant. He's really good, but he's not Kobe. He's not Michael Jordan. The people that get to the very top are the ones that spend the greatest amount of time in individualized practice, working in the dark when nobody's there to see it. Those are the ones that get to the top. And so you might get a head start, but you don't get to the top without a lot of work.
Yeah, well, it's interesting because I think, Dan, a lot of people who became successful were involved in sports. And I think there's certain lessons in sports of discipline, of hard work, of improvement, of teamwork, all of that, even being able to accept disappointment at times. And I really loved basketball growing up. And I went to Pete Maravich's basketball camp. I probably was 11 years old. But something he said always stuck with me. He told us, and of course, he was one of the greatest basketball players in the world. He said wherever he went, he took his basketball. If he went to the movies, if he went to school, he was always practicing, always. Because in his mind, he always believed if he wasn't practicing, someone somewhere else was. And when they met each other, that person would be better than them. So if you really want to be the best at what you do, you got to be really committed to putting in the work and putting in the practice. And that really stuck with me. And I transferred a lot of that from sports into being a trial lawyer.
That's a great analogy, because I always tell people it's about the reps, and people are like, what do you mean? I'm like, well, did you ever play a sport in high school? And people that had, I'm like, well, what'd you do every day after school or before school, depending on your sport? And they're like, practice. And what'd you practice? The fundamentals. And why? Because you can never practice the fundamentals too much. And so many trial lawyers don't practice. They think that going to trial is practicing. Going to trial is performing. Practicing is doing the work beforehand, doing the focus groups, recording yourself, having a coach give you feedback on your presentation, getting feedback from others on your presentation who maybe know more than you about presenting. That's practicing, so that when you go into that courtroom, you're doing things a little bit better and you intentionally do things to be a high level performer. I think it's a real difference there. So, Dale, you out to California, you're 29 years old, you take the bar exam and you pass. So tell us about your journey from the day you get that envelope in the mail that says, "Congratulations, you have passed the California bar." I assume it wasn't the internet wasn't working back then in 1989 or whatever year it was, and I'm pretty sure it wasn't because I was in college then and we're just discovering it. But when you get that ticket, tell us about the trip from that day to sitting right here on this podcast today and the stops along the way.
Right. Well, my path has been anything but normal for sure. One thing I can tell everyone, I've never had a mentor. I never had all of this instruction we have now available. I think the young lawyers have such a tremendous advantage of having colleges and being able to listen to accomplished trial lawyers and their journeys and what's made them successful. I never had any of that. In fact, I didn't know where I was going to go work. I looked in an ad in the Daily Journal. It said PI firm hiring new admittees. I thought, this is great. I could get a job. My dad did PI and I could learn a little bit. I go for the interview, I get hired, $3,600 a month. And I was thrilled. $3,600 a month, I'm getting a check. This is great. I thought, well, I can learn from all these lawyers in the litigation department. And I said, well, who else is in the litigation department? And they basically told me, you are the litigation department. You got a deposition tomorrow, arbitration on Friday, and you start trial on Monday. So there I was at 30 years old, reading at night, what's an arbitration? What's a deposition? So I was just really thrown into the fire. And I worked there for about 1.5 to 2 years. I learned a lot because I had to, but I realized they were not a reputable law firm. They were just really a PI mill with a litigation department. And so in 1991, I opened up my own law firm, and I really was just hustling any case I could get. It's interesting because one of the cases I had, I would take any type of PI case. It could be worth $3,000, $5,000. It didn't matter to me. I was just trying to pay the rent. And what's so interesting is, and I was really a patient, friendly guy, but one of my clients who had 2 cases that were worthless called every day, every other day, wanting to know the status of his case. And it was unbelievable. My staff told me, he's here. He's in the reception. He's demanding to see you. And I took the 2 files. I said, let me have his files. And I was intent on giving him back his files and saying, listen, I think you need to find someone else to handle your case. And I saw him. I invited him into my office. I had just bought all this new furniture. I actually leased it because I didn't have enough money to buy it. I looked like $1 million, but I was robbing Peter to pay Paul. He looked around the office. I think he was shocked that my office looked that good. 2 days later, I told him I would try to help him with the case. Just be patient. 2 days later, that guy referred me my first multi-million-dollar case. The same guy that I was going to send home and tell him, sorry, I can't help you, referred me my first multi-million-dollar case. And this case involved a young girl named Shauna Showman who was crossing the street in Burbank, hit by a car, blinded, brain injured, and no liability any which way you turn. The driver had $15,000 insurance. He wasn't working at the time. The only possible theory of liability I could figure out was a dangerous condition on public property. How come the motorists on Olive Avenue don't know that Burroughs High School is 1.5 blocks away? How come there's not signs there that these students are crossing as these motorists are going down the street. So then I was asking around. I was told it would cost at least $100,000 just for experts. I thought about referring the case to Brown Green at the time. I didn't know him, but I knew of him. I finally said, no, I'm going to try to do this myself. One problem, I don't have any money. So what do? I start doing criminal defense cases like crazy. I was down at the jails 5 days a week. Everybody had my card, even people that didn't want it. I'm getting calls, 5, 10 a day. I'm taking payments. I'm taking everything. And I hustled to raise the money for the blind girl so that I could prosecute her case. What ended up happening is two things. One, I became a good trial lawyer because you have to be doing criminal defense law. And I won 6 acquittals in a row in one stretch, had 2 cases on court television. That's where I developed my confidence as a trial lawyer. And secondly, I eventually won my first multi-million-dollar verdict with the blind girl, which catapulted my career in 1997. And I'll tell you one other story, Dan, and I don't want to go too long with this, but I think this is important. In 1993, I lost 2 cases in a row after winning 5. They were both criminal cases. There were significant sentences. I was so heartbroken, so emotionally upset, I was thinking of no longer being a trial lawyer. In 1993, I was going to stop being a trial lawyer because I didn't think I could take the losses or the emotional upset of losing. And I didn't try a case for a whole year until I jumped back in the saddle again. And that's when I won the 6 acquittals in a row. That's where I rebuilt my confidence. And that's when I won the blind girl's case. And if it wasn't for all that, I never would be where I am today.
Well, I know I used to do criminal for like 18 years back in Detroit. And I remember I had a stretch where I actually lost 10 trials in a row. And, it really shakes your confidence when you when you work your ass off and you get punched in the face, you get knocked down, you get stomped on, and, you have to peel yourself off the ground to get your, to find the mojo, because it's such a confidence game. And when you lost it, and it's been, shattered because of devastating defeats that, haunt you, it takes a little focus to get back into the saddle. And that's why, when people are talking about getting, experience, and they're going to go, try a case that might be like a crappy case, not a small case. There's small cases. I think I like small cases, but not cases that aren't worked up properly because nobody really put the care into them because they considered it a little case, and you go into court and get your ass kicked. Well, it doesn't matter. It's a public humiliation, and that can really start to, to break a young trial lawyer. So I think people need to be real mindful of that stuff. To get, you get reps. Everybody needs reps, but make sure you got a decent case, even if it's a little one, because your mindset, so much of performance is your self-image is crazy. But when did you know that you really wanted to be a trial lawyer? Like, the trial was that the courtroom was your dojo.
Well, I think it was a series of events. The first thing I remember when I was inside a courtroom, when I started making appearances and looking around and looking where the judge sits and looking where the jury sits, I started getting this feeling inside, like, this is pretty amazing. Like, I think maybe I could be a trial lawyer. I'm not sure, but I'm getting a feeling of excitement inside me just by looking around and being in the courtroom. Then, when I did preliminary hearings, for example, in criminal cases, I started getting a lot of feedback from other lawyers and judges. Wow, your cross-examination was really good. That was amazing. How long have you been practicing? And so when people tell you you're good, maybe you're a singer, a musician, an artist, but whatever you do, when you start getting positive feedback, it builds your confidence. And you start realizing, hey, this might be something I'm really good at. So I think it was between the two, getting that positive feedback and feeling a certain comfort inside, that made me think I could be a trial lawyer. I at least want to give it a try.
and give it a try, you have. So, but you really focus on the area of civil rights, and you're the only. I mean, you focus on it more than any other top trial lawyer in this country. So, tell us how that focus, how that passion for civil rights and to hold the government and the police accountable for their misdeeds. Where did that arise in you from?
Well, I think part of it is just my makeup as a person, and then part of it was experience over time. I'm generally a very sympathetic, compassionate person, always for the underdog. I'm the type of person in high school that didn't like seeing someone bullied. I'd come to their defense. I was the type of person in high school that liked everyone, whether they were mentally or physically disabled or considered to be nerds. I just have a protective nature about me in general. Then I started in my work as doing criminal defense law, as you know, Dan. I started seeing how comfortable police officers were with fabricating reports, testifying falsely. It was unbelievable to me. Every case, essentially, I guess in their mind, the ends justify the means. So if they think that your guy's guilty or a bad guy, so what if they testify falsely as to how it really happened? But that really bothered me at my core. Then there was Rodney King. I also was influenced to some extent by Johnny Cochran, knowing some of the work he had been doing and watching him in the OJ case. And I knew that police officers were literally getting away with murder and there was no accountability. No one was being criminally prosecuted. No one that I knew was taking these people to trial and winning. So it really sparked my interest is I'd like to find out what's happening with civil rights cases and how can I get into civil rights and how can I help people stand up against bad cops, against all this abuse of authority. How can I be their voice? And that's where I got the idea. I want to use my talents as a trial lawyer. There's many great PI lawyers. There's many great criminal defense lawyers, but maybe this is an area that I can help with and make change. And so that's what I decided to do.
And so in the last year, how many civil rights trials have you completed?
In the last year, 7. I won 6, and my last case was a hung jury, 7-1, my favor. I normally try about 10 trials a year. Sometimes I've tried as many as 14. More recently, the majority of my cases settle. I think I've settled 21 cases already this year. So, last year I had my last 3 cases were 8-figure verdicts. So I think I finally got their attention where they're strongly considering settling with me rather than going to trial.
Well, that's Brian Pash. I talk to him all the time. He always has the same complaint. Ambrose, they just keep paying me. I want to go to trial. This is bullshit. I'm like, I know, Brian. I said, I feel so bad for you. I mean, he's like, anyways, but that's what happens, right? If you whack them,
Yes.
and if you keep whacking them, they keep paying.
I was joking with Brian. He told me the same thing, Dan. And I said, well, Brian, first of all, your cases are all so good. And second of all, they're throwing so much money at you. How can you say no? I say, you want to go to trial? I'll give you some of my cases.
That's a good one. I got a case for you. You really want to go to that courtroom? They're not paying shit on
Yes.
this one. You just go get to my client that was on meth and resisted the police and got killed. You go represent that guy with his long criminal history too. Yeah, that would be
Right.
those are these because civil rights are the toughest cases. The toughest cases. Last year, you came to Huntington Beach and you did a 2-day master class that was extremely well attended and received and reviewed on civil rights. And that class is on TLU on demand, which has this. It was a 12-hour class. So can you tell us this year, and you're coming back and you're teaching evolved civil rights class. It's going to be different. So tell us like this year, how's the class you're going to be teaching different than what you did last year at Huntington Beach?
Well, it's going to be more detailed. You know, when I started doing these cases, Dan, about 22 years ago, I devoted full time to these cases. The percentage of plaintiffs' verdicts against the police was 10%. So out of every 10 cases tried, civil rights, police excessive force, 9 were won by the defense. And I was determined to change that. And over the next 10 years, I was about 50-50. I was winning about half my cases, losing half, but I started getting multi-million-dollar verdicts in some of the cases I won. Then in 2011, that's where I really hit my stride. I won 10 trials in 1 year. They say that's never been done before in civil rights, someone to win 10 civil rights trials in a year.
So, Dale, this class that you're teaching in Huntington Beach, it's a 2-day class focused just on civil rights. And so tell us what it is that you're going to be covering on day one.
Day one's focus really is everything leading up to trial. In other words, the factors in deciding whether to take a case or not, what you have to do prior to filing a lawsuit, where you should file your lawsuit, federal court or state court, what are the advantages and disadvantages of each, what should be in your lawsuit in terms of claims, what damages can you get under federal and state law, written discovery, depositions, how to effectively take police officers' depositions, experts, getting around qualified immunity, surviving summary judgment, pretrial issues, bifurcation, motions in limine, everything you need to do prior to trial to give yourself the best chance at either winning at trial or getting a favorable settlement. That's the focus of day one.
Okay, and just before we talk about day two, you mentioned bifurcation. So in what types of civil rights cases do you want to would you be looking to bifurcate damages and liability? Is that what you're talking about? Damages and liability is just separate? Okay.
Yes, I mean, there's different types of bifurcation, right? Monell liability, punitive damages, but just to focus on compensatory damages and liability. So you may have a lot of negative evidence. One of the most challenging parts of these civil rights cases is you've got negative evidence, right? Criminal history, drugs, alcohol, prior incarcerations, etc. And a lot of the evidence the police didn't know at the time. They didn't know all that at the time. You file motions to exclude it, claiming the police didn't know it. It's not relevant to the analysis as to whether the force was excessive or not. But the other side oftentimes will say, yes, but it's relevant to damages. You're asking for millions of dollars. You're pretending like you have a choir boy here. Doesn't the jury have the right to know he's got an extensive criminal history, that he's been a drug addict for most of his life, that the mother has a restraining order against him, or whatever the case may be? So in cases like that, I think the plaintiff should strongly consider asking the court to bifurcate liability and damages so that the jury decides liability without hearing all this negative evidence that the officers didn't know. If you get that finding, you're going to get attorney fees and you're going to get some money. But if they hear about all that baggage in the first phase, you may never get liability because they'll think this guy's a bad guy.
All right. Now, part of what you mentioned also was taking effective depositions. And I know that a lot of the cases that you're brought into, that you try, are brought to you by other lawyers. So I imagine you have to read a lot of other lawyers' depositions. So what I want to ask you is, what are some of the most glaring mistakes that you see lawyers making in these depositions of, the offending officers or their police practices experts that the defense brings?
Well, I think that's an area where people can really improve. And fortunately, most of the cases I get, I do the depos or my office does. Most people bring us on very early on. But there are cases where I come in and I'm reading depos that the other attorneys took. I could put it to you this way. I use certain police practice experts, Scott Defoe, Roger Clark, Jeff Noble. They have told me when they read my deposition transcripts, every page there's points, good points being made on every single page that they can use to support their opinions. When they read other lawyers' depositions, they're reading 100 pages and they can't even use one thing. That's how bad it is. So my advice on that is you have to learn how to ask very crisp, short questions, usually demanding a short answer or yes or no to get a concession from the officer. You are there to get concessions from him to survive MSJ, to settle the case, and to set up your cross-examination at trial. Similar, Dan, to what you would do at a preliminary hearing. If you got a chance to cross-examine someone who you know is going to testify at trial, that's going to be the basis of a lot of your cross-exam. You're going to catch them off guard. But for example, if your question's very short and crisp, did you ever see a gun at any time, for example? Or did you ever give him a verbal warning you were going to shoot, for example? You can use that. If your question starts, so on the day in question, when you got out of your car and you were looking down the road, and by the time the question is done, it's so long, it's so compound and convoluted, you can't use it. So you got to really get good at asking short, crisp questions. It's like playing pinball. When I do a deposition, it's like pinball. It's like, if I hit that thing, I'm going to get 10 extra points and the machine's going to start going crazy. That's what my deposition is, because every page I'm making points that are going to help win the case.
All right. Let's talk about day two, because day two is a little different. Day two is really focusing, I think, on a different aspect of the litigation process.
Yeah, so
trial.
Everyone's been wondering, like I told you earlier, Dan, when I started doing civil rights cases, 10% were won by the plaintiffs. We have a mediator out here named Rick Copeland. He keeps the statistics on all the civil rights cases. I win 91% of my trials. 91%. And he said the next highest person is 25%. Okay. And those aren't my best cases because I'm settling my best cases. So obviously the whole reason that I teach and the whole reason people want to come and learn, how in the world does Dale do it? How could he win 91% of his trials with impossible facts? And part of it is day one, because the foundation is important. But day two, Dan, really focuses on all my trial secrets. What do I do during jury selection? What don't I do during jury selection? How do I frame my opening statement? What order do I call the witnesses in? How do I present my experts at trial? How do I present the plaintiffs at trial? Everything I do from A through Z, including closing argument, rebuttal argument, jury instructions, verdict form, all of my little tricks I explain in day two.
These little tricks, or what do you want to call them, skills, things that you do, you obviously are constantly applying those in the actual, in the courtrooms, and probably refining and improving the stuff that you're doing every time you step in there. Because I always figure for every trial lawyer, their last trial, their last case, was their best, was all their effort, all the lifetime of 35 years of being a lawyer, you put to practice. And you were saying that, you had six wins in a row. The last 3 were 8-figure verdicts. And then you had this hung jury up north, like with 7-1. So, but let's talk, I'd like to ask you, about your philosophy on trial and start out with the 90 days before trial. So this case, let's talk about what was the trial about right before the hung jury, where you got an 8-figure result.
Okay, that trial was a young man who had a mental health breakdown, ex-military, probably had post-traumatic stress disorder, got in an argument with his sister, and then a fight with his mom's boyfriend. They called the police. The police thought he had a machete and a hammer and was attacking family members. He ran from the location. The cops saw him. The cops claim he was running at him with a machete and a hammer, and they had no choice but to shoot him, and they killed him. And I represented the mother. I think the highest offer was $300,000. The jury verdict was $23.8 million. It just settled. I got the check yesterday, thankfully, and for the full amount. And then the statutory attorney fees were about another $1.5 million on top of that.
Wow, that's a hell of a result. So let's talk about that trial, though. So getting ready up to trial, because you have a lot of trials going on. So what are the things that you're doing to make sure that that trial that's going to go in federal court is dialed in and ready to go?
Yeah, I think most trial lawyers, they have their routines, probably like most athletes. You know, people getting ready for the Olympics right now, they're probably going through their routines, knowing that the Olympics are coming up. And I kind of have my own routines. And because it's worked for me over the years and it's comfortable for me, that's what I stick with. I like looking at the big picture, but I also like looking at details. So as I'm preparing a case, same with like when I would do criminal defense law, and I love trying criminal cases, Dan, because I'm looking at the big picture. What are reasons for reasonable doubt here? But I'm also looking at some of the details, because sometimes the details are really important. So I start by reading the statements of the involved officers. Why are they saying they used force? I reread their depots. I read the expert reports. I start reading the expert depots, and I start formulating in my mind how I'm going to best present this case to the jury. How am I going to frame it? For example, in the last case I did, I can't argue that the guy was no threat at all if he's running around with machetes and hammers. That's not going to work. I can't argue that the police had no reason to be concerned. That's not going to work. I have to argue they didn't need to kill him. That might work, right? But only if I could establish to the jury the very high standards required to kill another human being, and explain to them all the other options they had, and explain to them what they should have done rather than killing him under these circumstances. So I'm just absorbing the information. Then I start making my outlines, Dan. I outline the examination points of every witness. I outline my opening statement, my closing argument, my rebuttal argument, all before the trial even starts. By the time of the trial, it's pretty much all up here. I just look at a few notes and I know the points I want to make. But that's I also write down pre-trial issues, problems I have with negative evidence, things I got to talk to the judge about, things I want to ask during jury selection, because some people might have strong feelings about drugs or other things, and I need to know about that to see if they could be fair.
Well, let's talk about, since you brought it up, let's talk about jury selection, because most of your cases are in federal court where you get little to none jury selection, but sometimes if you get a real liberal judge, you might get 15 minutes. So when you got 15 minutes in these civil rights cases, tell us how you're utilizing those 15 minutes to find the jury that's going to deliver your $23.8 million verdict.
That's a very challenging question, and I go to in detail at the seminar, but I'll give you a few thoughts. First is got to be time management. You got 15 minutes. So you have to figure out, what questions do I really want to ask? Because I'm not going to be able to ask all the questions I want. So what are the most important group questions? What are the follow-up questions I want to answer? And from my perspective, I always consider, what are you trying to accomplish? Because I think a lot of trial lawyers that aren't real experienced are just getting through it, right? They're just doing what they normally do to get through jury selection or get through their opening statement. And they might not be carefully thinking about, what am I really trying to accomplish here? So what I tell lawyers, the first thing is, be likable. You're not going to change these people's opinions about police and about their political beliefs in 15 minutes, okay? Be courteous, personable, likable. Don't be cross-examining the jurors. You'll look like a jerk. Be friendly and be nice. That's number one. Number two, if you're going to ask some group questions, for example, I might ask, who feels they're a very strong supporter of the police? Very strong supporter of the police. Now, if 5 people raise their hand, I know those could be potential problem jurors for me, right? I got to explore that. And so, I know drugs is a big issue. Let's say the judge says drugs are coming in. I'm going to want to tell the jury, look, everybody understand this is an officer-involved shooting? Yes. The issue in the case is whether the use of deadly force was excessive or not. That's the issue. Do you understand that? Yes. So you may hear about drugs. I don't expect anyone to be a fan of drugs. I think the drug in this case is methamphetamine. I need to know now, does anyone have such negative feelings about drugs or methamphetamine that if they hear that, they're done? They won't even be able to focus on the issue. It would be very difficult, if not impossible, for you to be fair if you hear methamphetamines involved. And about 2 or 3 people will raise their hand. And if I have 3 negative facts, maybe the guy's armed with a weapon, maybe he's got a criminal history, I bring those up, Dan, and I try to either challenge those people nicely for cause, or I try to get a commitment from them that they'll put that aside, understanding that's not the main issue. But I think you have to deal with the elephants in the room and that negative evidence in jury selection.
And so in the case that you got the 23.8, what were the tough issues that you had to deal with that one? I mean, I obviously got the machete and the hammer. That's
Okay.
for sure.
Yes, the machete and the hammer, not obeying verbal commands, potential mental health crisis, right? Or mental illness. Some people are very sympathetic to that. Some people are thinking if someone has a mental illness, they're crazy, they're violent, who knows what they could do. And some people have people in their family with mental health issues. So those were the main things there. I think he might have been drinking some alcohol. So I asked a little bit about alcohol, but I think that was more or less a non-issue. And I might ask questions like this. Do you think police officers on occasion use excessive force? If there's people that don't think they ever use excessive force, they're bad jurors for the plaintiff. Do you think police officers can make mistakes in using excessive force? Do you think they should be accountable if their mistake kills someone or seriously injures them? So those types of questions will start giving you a feel for what these jurors are thinking and feeling. Sometimes I ask the jurors, is there any reason you can think of that you would be hesitant to vote against the police in this case? For any reason. Maybe you're a strong supporter. Maybe you think they have a tough job. Anything you can think of. Because those people might be difficult jurors for you and you need a unanimous verdict in federal court.
So moving from when you got your jury, opening statement, your best practices, philosophy on opening, and really in reference to that last verdict with the machete and the hammer.
Right.
What are you trying to accomplish with your openings?
Well, a lot. First I want to connect with the jurors. I want to have credibility, likability. And I very rarely look at any notes. I very rarely look at any notes. I stand before them and I look at them and I deliver it. I also want to focus them on the issue of the case, right? Like, for example, the issue in the case is whether it was appropriate or necessary to use deadly force. And then I explain in my opening what the standard is. When can officers use deadly force? and when can they not? And I do it through the evidence because I ask the officer those questions at depositions in terms of their training, in terms of the policy. I ask both experts on both sides that. I know there's post standards which apply to what police officers can and cannot do. So I spend about 5 minutes telling them what the standard is. For example, a weapon in someone's hand is not enough. For example, someone being resistive or assaultive is not enough. For example, someone being a threat or potential threat is not enough. It's got to be an immediate or imminent threat, and the level of threat has to be death or serious bodily injury. A warning must be given when feasible, and you have to look at whether there's other reasonable options, and they're responsible to justify every shot. And I go on, and I create this so high of a standard, then I tell them what happened. And most of the times the reaction you could tell is, why the hell did they shoot him? Now, I did have one benefit in that case, Dan, and that was the video of the shooting from the 2 officers' body-worn cameras. And they thought it helped them, the video, but I thought the video was horrible for them and great for us because he originally was running in their direction, but then turned and was running down the sidewalk when they shot him and killed him, not directly towards the police officers. And then there's video after the shooting of him dying in pain, which was one of the reasons I think the verdict was so high. It was just gut-wrenching. And he had been ex-military, so I think there were sympathy points there for him, served our country. So I didn't show the video in my opening. It was great for me. I kind of wanted to show it, but I didn't think it would have maximum impact. Then I thought, is the other side going to show the video? No way. If they show the video, they'll look like idiots because the juries will be looking at them saying, do you actually think this helps your case? So what did I do? I put the officer on the stand, Officer 1, got him to tell his exaggerated story of what happened, completely contradicted by the video. And then there was 15 minutes left on day 1. I turned to the judge and I say, okay, Judge, I think it'd be good for us all to see the video together now. And the case was over because the video completely contradicted what the officer had just been telling the jury for 45 minutes. And so that was very powerful for us. So I try to connect with the jury, frame the case, set the standard, tell a story, add some sympathy points, but I try not to oversell it, Dan. I think some lawyers try to oversell the case. You just want the feeling like, look, if what this lawyer said is true, he deserves to win the case. You also don't want to take away the jury's role. Let them feel important, right? I kind of am empowering them from the beginning. We need your help to listen to the evidence, to judge credibility, to decide what happened here. You know, I invite you to pay close attention, and I thank you so much. You know, kind of get them interested and involved so they're kind of excited and they want to help you and they want to, you know, do what's right.
Let's talk about order of proof and, you know, specifically in this case, how you think about witness sequencing.
In my cases, usually, like I had 2 shooting officers in the case. So I put them up first because I wanted to get every concession I could out of them. In my own mind, Dan, I'm saying I want to win the case even on the cross-examination of the officers. So I'm trying to win the case in every phase. I want to be ahead of jury selection. I want to give a better opening statement, and I want to win on the cross-examination of the officers. There were 4 other officers that arrived at the time of the shooting. I called some of them to show that what they said was inconsistent with what the other officers said. So I didn't see any hammer in his hand. I didn't see a machete. It didn't look to me like he was running at the officers. It looked like he was running down the sidewalk, for example. Then I called the paramedics because I had gut-wrenching video of him dying at the scene, on the way to the hospital. It was very powerful, even in the ride to the hospital. Then I called my police practice expert to lay out what the jury was already feeling. Everything they did was wrong and they didn't need to kill this kid. Then I called the family members and the mother.
Time out. Let me ask you about that police practices expert before we get to the family members. How do you go? You said you work with a few different police practices experts. And how do you think about, and you have all these different types of civil rights cases. And so in this particular case, why did you choose the person that you chose out of the different experts in the field?
Well, interestingly, in this particular case, I took it over from another lawyer about, I don't know, maybe 9 months before trial. And the other lawyer had picked a police practice expert that I had never worked with. So I talked to the guy. He seemed like a nice enough guy. And I decided to have him continue on in the case. And I kind of worked with him. I thought the video was so strong, we'd be fine. And, you know, how many times have you worked with Mr. Galipo before? Oftentimes they have to say many. Him, he said never. So that was kind of good. So I worked with him a lot because I hadn't worked with him before. And I thought his testimony was good enough. It might not have been great, but it was good enough in that case.
All right. And so after your police practices experts in your case in chief, you said you talked about family members and whatnot. So who's up generally in your sequences?
Yeah, and I want to say a word about the experts, right? Because I hear from a lot of experts that they wish that the attorneys would handle them better. They don't feel like they're doing as good as they could, in part because of the lawyers. And I asked them, well, what do you mean? First of all, they don't spend much time prepping, telling me what they want to focus on, telling me their theory of the case. They just say, show up, and I go, and it probably would have went better if we had spent an hour prepping, right? Show me the exhibits you want to use. Let me know what's been happening so far in the trial. The other thing is, they're very sensitive about their qualifications. So this is a delicate balance, right? You don't want them up there for 20 minutes saying how great they are, because that's a turnoff. But you want maybe 5 or 7 minutes where the judge and the jury says, wow, this person's pretty impressive. I want to hear what they're going to say. So decide what you're going to go over. But then when you get to the opinions, this is what's important. Let them say their opinions. Some lawyers want to do the talking for the expert. So you think this was excessive, right? And you think this was excessive because he wasn't running right at them, correct? That's not as good as, did you reach an opinion in this case as to whether or not the deadly force was excessive or not? Yes, I did. What is your opinion? I think it was excessive. Can you explain to the ladies and gentlemen of the jury why you thought it was excessive in this case? This is where you got to start giving them softballs, right? And let's say there's 10 points that you think are your best points, right? He was running down the sidewalk. He hadn't hurt anyone previously. Whatever they were, I asked my expert, was it important to you that he was running down the sidewalk away from the officers? Oh, yes, that was really important. Can you explain to the jury why that was important to you? Softball. Why? They'll turn to the jury. Well, the reason that's important is because obviously if he's running away from the officers, there's no immediate threat of death. And then you go to your next point. How about the fact that such and such, was that important to you? Oh, yes, that also was very important. Can you tell the jury why that was important to you? So now you're giving them all these softballs. They're the star. You also ask them, I asked my experts, tell me the main points you want to talk about, the points you feel passionate about. And I make sure and ask them a softball question so they can do that. Now, the other thing is the other side's going to beat them up, object when necessary, but don't overly object, but come back in your redirect. Use 5 or 10 minutes to focus on the good points again. Did anything in any of the questions Mr. Smith asked you change any of your opinions in this case? Not at all. He asked you whether you generally do plaintiff's cases, correct? Yes. And you said the majority of your cases are plaintiff's cases, yes? Do you turn down cases? Yes, I do. Why didn't you turn down this case? Well, because this is one of the worst shootings I've ever seen. As a matter of fact, all of a sudden you get a jewel on redirect. So, and then that's the last thought the jury's left with. And then what's the other attorney going to say? Well, your expert just said this is one of the worst shootings he's ever seen in his life. Anyways, just a few points to consider when using your experts to get the most out of them and make them comfortable.
Okay, so, but the lay witnesses, the family witnesses, the damages witnesses, tell us from what you just shared with us, they followed the expert, but what kind of testimony were you looking for from these folks to help drive the damages, the verdict, the value of a life that was taken?
Right. Well, everything up to them has been kind of, here's what happened, here's the evidence, here's the forensic medical evidence, here's the police practice testimony, here's the standards. They bring a whole nother component to this. They bring the reality of what it's like to have a loved one killed by the police. So I don't believe that testimony has to be long. I've had mothers on the stand for 10 or 15 minutes, and it's been heartbreaking. First, I get 10 or 20 really great pictures, because that helps a lot of people, right? Tell me about this picture. Oh, that was when he was, playing baseball, and I used to go to all the games, and he really loved baseball. And what's this picture? Oh, he loved playing the piano. That's when he was at the recital. And how about this? Oh, here's when he would join the Navy. He was so proud to serve his country. I was so proud of him, and then you can kind of start having the discussion. Tell me about your relationship with him. Tell the jury, what type of person was he? How would you describe your son? Oh, he was a wonderful person. He was so giving. He'd give you the shirt off his back. Everyone loved him. He was like my best friend. What were some of the things you enjoyed doing together? Oh, gosh, we loved doing everything together. He loved to cook. He would cook me breakfast. We'd go out sometimes. We'd watch movies. All of a sudden, the jury is just memorized by the closeness of this relationship, how much they loved each other, what they did together, all about him. Then you ask, how did you find out that he was shot and killed? Who told you, right? Where were you? Everyone can imagine getting that call. And what were you feeling at the time? What was going through your head? Where did you go? I went to the hospital. They wouldn't let me see him. There were police officers guarding the room. I was crying hysterically. I was begging them to let me see my son before he died. They wouldn't let me in. I mean, it's heartbreaking. How do you think this has affected you? Right? And I tell them, here's the 10 questions I'm going to ask you. So let's think about it. How has this affected you? Do you ever think you'll be the same? It's heart-wrenching. They start crying. A piece of my heart is missing. My best friend is gone. I'll never be the same. I'm having my own health issues now. And so that gives you that emotional. And sometimes you need it, Dan, for conservative jurors, because a lot of conservative jurors are very pro-police. They're very reluctant to vote against the police, but that emotional hitch could make a difference. Also, if you have children, a lot of people are hesitant to put children on. I think if they're old enough and they're comfortable, put them on, even if it's 3 to 5 minutes. The jury will fall in love with them. What's your name? How old are you? What grade are you in? Who's your teacher? Do you like school? What do you like doing? Do you miss your dad? Do you have a picture of him? Where's your dad now? He's in heaven. It's just heartbreaking. So now the jurors sometimes overlook some of the bad actions the father took, and they're looking at those kids and they're looking at the mother and they're thinking, man, I don't feel comfortable voting against them. I feel like I'm helping them, help their pain, help their closure, help their future. So now they're looking at the mother and these beautiful kids versus these two cops who lied their you-know-whats off and killed this guy for no good reason. And then what I do, Dan, to inflame damages in my rebuttal argument, and I know we're going to get to closing in a little bit, so maybe I'll wait for that, but I get upset because they deny responsibility completely, even throughout their closing argument. We're not responsible at all. It's all the decedent's fault. These officers have tough jobs. They got to make split-second decisions. They could have been killed, or whatever they want to say. And that's when I get upset at the end in my rebuttal. I get a little extra passionate because kind of holding it in the whole trial. And I tell the jurors, now you see why we're here, why we've been here for 7 days. It's because the city of Los Angeles and their officers refuse to accept any responsibility for his death. They want to blame the mother. They want to blame the sister. They want to blame the decedent who's not here to be able to talk for himself. They're not even willing to accept any responsibility. That's why we're here, ladies and gentlemen. So a lot of jurors are not happy they've been there for 5 or 7 days. And they don't know why. Maybe because the plaintiffs are too greedy, right? Now they find out they're here because the defense isn't accepting any responsibility at all. So now they're extra pissed off. Now they're going to even award more money to make sure they get the message that this is not going to be tolerated.
Got it. Cross-examination. Because really the cross-examination, if you call their cops, in your case in chief, it seems like in most cases your cross-examination is very limited to perhaps, them recalling their defendants or their police practices expert.
Yes. Well, first of all, I got to tell you, really good trial lawyers, they're good storytellers. They're good at putting it all together like an opening and closing. But I think even a greater skill is the skilled cross-examiner. And I'll be honest with you, of course, I don't have the benefit of watching all the great trial lawyers in trials because I'm usually busy myself. But I haven't seen a lot of what I would consider great cross-examiners. I know there's many out there. I know most of the guys in your college, Dan, and that you've done webinars on, they are, I'm sure, really good. But it is one of these skills that you really have to work on and work on and work on. Most people think they're much better than they are, okay? They think they're much better than they are. And you could read deposition transcripts and you could quickly see who's good and who's not very good. Or you could sit in a courtroom, as you do often, Dan, and watch great lawyers, and you could see who's really good and maybe who thinks they're better than they actually are, right? So that is a skill. You've got to develop that from the beginning. If you're not a good cross-examiner, it's going to be really difficult for you to win civil rights cases. The same with criminal cases, right, Dan? I mean, the greatest skill a criminal defense lawyer has is cross-examination. No matter what you throw at them, they're good on their feet, they'll neutralize it, they'll even turn it their way. And also, of course, they're great in closing argument, explaining why there's reasonable doubt and summarizing the evidence. So, yeah. So I do want to mention this. The police practice expert.
Who was the police practice expert on the other side in this case?
Trying to think. I think it was Ed Flossie. I'm not 100% sure, but I believe it was Edward Flossie, who the city uses a lot, who's ex-San Jose Police Department, does all defense work. A lot of cases for the city. I think he's done 80 cases for the LAPD. Crazy, right? So here's the thing. No matter how good you think you're doing, and I usually tell people you're not probably doing as great as you think or as bad as you think. Because most people are like on one end or the other, and they're probably better off in the middle, right? Because you don't know what these people are thinking. You know you're doing pretty good, but you always got to finish strong and don't take anything for granted. So Usually the last witness called in these police cases is the defense police practice expert. And it's very painful because no matter how good you think you've been doing, they're up there for 45 minutes to an hour, re-explaining the facts of the case, rewriting the standards, and explaining to the jury how tough jobs police officers have and why they did not violate the standards in this case. And you got to listen to that. And what's even more scary is you're glancing over at your jury and people are nodding their head, taking notes, and you get this sinking feeling. So you have to be able to effectively cross-examine the police practice expert. And I really break this down in the seminar that I'm going to be doing, Dan, in Huntington Beach, and share a lot of secrets as to how I do it. And some of it is establishing the bias. Some of it is having them review your favorable facts. Some of it is resetting the standards and giving them hypothetical questions. And of course, some of the foundation for it is your deposition. But I have been very successful at neutralizing their police practice experts and even making them my experts by the time I'm done with them. And it's a great segue because it's usually the last thing they hear before closing argument. So now you got momentum going and, now closing argument. So it's really good stuff.
Dale, I recently wrote a cross-examination for police officers, and then we kind of flexed it a little bit for a defense medical expert. But I'm going to give it, because we talked about the cross, and this is a foundational piece of cross. So we're going to pretend you're the cop. I'm going to do my short foundational cross with you.
Okay.
And then we're going to have feedback on it, okay?
All right.
So we're going to call you, it's going to be Deputy Galipo. How does that sound?
Well, it sounds okay. I don't think I'd ever be a law enforcement officer, but I'll live with it.
Dale, you could be mistaken for a cop. All right. I'm just saying.
I've been mistaken for a lot of things.
All right. Ready? Deputy Galipo, you're a professional police officer.
Yes, I am.
To become a professional police officer requires highly specialized training.
Yes, that's true. We have a lot of training.
This training, it takes place at the police academy.
Some of it at the academy, and then we've had ongoing training since the academy.
At the academy, you take classes.
That's correct.
One of the classes that you take is on how to conduct a proper investigation.
Yes, that's true.
You're trained that a proper investigation must be impartial.
That is correct.
And by impartial, what we mean is that, you look at all the facts, both the good and the bad.
Correct. We try to do a thorough investigation in every case.
You're trained that a proper investigation must not only be impartial, but it must also be objective.
That is correct.
And by objective, what we mean is that you don't allow your emotions to dictate how you do your investigation.
Well, some of these cases are emotional, but you are correct. We stick to the facts and we try to be as objective as possible.
Deputy, you're trained that a proper investigation must not only be impartial and objective, but it must also be complete.
That is correct.
And by complete, what we mean is that you consider all relevant information.
Correct. If it's relevant, we consider it.
Deputy, the opposite of a proper investigation would be a biased investigation.
I'm not sure I understand what you mean.
Well, what I mean by a biased investigation, that's the type of investigation where an officer chooses to only focus on evidence that points towards guilt and ignores all evidence that points towards innocence.
That would be improper. We're supposed to consider all the evidence.
Deputy, you're trained. There are certain risks associated with an officer's choice to conduct a biased investigation.
Well, I'm not sure what you're saying biased. If you mean biased in only considering evidence that supports the guilt, then I would agree with you. And we're trained that we should be objective and include all the evidence in the investigation, whether it supports guilt or supports not guilt. That's for a judge or a jury to decide.
Deputy, you're trained that, one of these risks is if an officer chooses to conduct a biased investigation, is that an innocent person could be wrongfully arrested.
There's always that risk.
Right? And Deputy, you're trained that if an officer chooses to conduct a biased investigation, not only could an innocent person be wrongfully arrested, but they could also be forced to stand trial.
Well, I would hope that an innocent person isn't forced to stand trial, but there's always that risk.
Deputy, you're trained that if an officer chooses to conduct a biased investigation, not only could an innocent person be wrongfully arrested, forced to stand trial, but maybe, just maybe, and most tragically, mistakenly convicted by a well-meaning jury.
Well, it has to be a case-by-case basis, but I do agree with you that all the evidence should be considered.
Well, Deputy, let me ask you this question. On December 14th, 2022, you had a choice to make. So, did you choose to do a proper investigation, one that was impartial, objective, and complete, like you were trained to do? Or did you choose to violate your training and conduct a biased investigation, knowing all the risks?
I felt that the investigation we did in this case was objective and unbiased.
Thank you, Deputy. So I really like that piece across because I think it really teaches all the fundamentals. It teaches looping. It teaches, one new fact per question, leading questions only, dropping all the taglines like right, correct, isn't it true? Dropping all the filler words like and, so, etc. Working with, the right way versus the wrong way. Plus it, like in real life, I use a flip chart. So I teach people how to use the flip chart and write the impartial, objective, and complete, and arrested, stand trial, convicted. So that way you got the visuals that you're making at the same time. But it really draws a line in the sand. And, it's like my friend, Roger Dodd says, it's like the dog that ain't interested in the fish that don't flop. By drawing that line in the sand, you're getting the cop, because we know it's just like how many police practices experts would you say are impartial, objective, and complete? Pretty much none, right? Because how the hell can that guy look at that video and say this is proper? But they're going to do it, and the guy does it every time. And so I think the great thing about the cross is that whether it's a cop, a police practices expert, a defense medical exam, it raises them up on a pedestal, showing that they know the right way to do it. They know all the risk of doing it the wrong way, but you know that they do it the wrong way because they don't care, because they have an agenda and they are biased. But then you get them to commit perjury right out of the gate and deny all this. So that way, and so now the jury's drawn in because they're like, okay, you just called this guy a lying, piece of crap, and now you better prove it. And you do. I think it has a decent impact on the audience. So,
no, I think it's good, and it also, really good questioning is provoking thoughts. Like you can't talk directly to the jury, but you want to talk to them. And you want to instill thoughts in their mind. So just by the way you ask the questions, the jury is starting to think, wow, we don't want to convict an innocent person here. What if we make a mistake? What if this investigation was biased? We have to consider all the evidence, not just the evidence going towards guilt, but also the evidence that might suggest this person's not guilty. So I do the same thing. Like when I'm crossing their police practice expert, I have 10 or 20 questions on bias that are really strong. Like, how many times have you worked for the city before? And how many times have you testified in deposition or trial? And how many have been shooting cases and death cases and unarmed people shot in the back? And you, in every one of those cases, testified that the shooting was appropriate. Every single one. And you got paid every single time. And you're getting paid in this case. And you got 5 other cases with the city. And you're testifying next week. And in every case you testified in, there was a police practice expert on the other side who disagreed with you. And you would agree that whether the use of force in this case was excessive or not is up to the jury. Oh, yes, of course, it's up to the jury. They decide the facts. So you're empowering the jury and you're taking away his power right before the jury. So, effective cross-examination 10 minutes in, they're thinking this guy is so biased and we have all the power anyway, so it really doesn't matter what he says. Then the other two things I do, Dan, because I'm getting ready for closing argument, let's say I have 30 really good facts for me in a case. Really good facts. My best facts. I say, you reviewed all the facts in this case, correct? And in reviewing the facts, you formed your opinions. So let's go over some of the facts and review with him your 20 best facts in front of the jury. You were aware there were 2 shots to the back, correct? Yes, I was. You were aware there was no verbal warning given that deadly force was going to be used, correct? Yes. You were aware one of the shots happened after he went to the ground. Whatever they are, and he has to agree with you, and you get to do it in front of the jury. And then, of course, the standards. He has to agree to the standards, and hopefully you asked him a deposition, so it's reinforcing what you've been telling the jury all along. Anyways, those are some good ways to neutralize their police practice expert.
All right. Well, we're at that part where we have to closing argument. So your approach, and specifically in your hammer and machete case.
Yes. Well, I love closing argument because it's your chance to put the whole case together. Everything, right? From the human psychology parts of it to what was discussed in jury selection, to the opening, to the witness summaries, to the closing, the law, the verdict form. I've gotten pretty good at it over the years because I've done it so many times. And you're going to get better each time, right? You think about what exhibits you want to use. If there's some killer testimony that came in, you might want to reference that. But you also want to, at the end of the day, it's the act of persuasion, right? You want to remind them of what the issue is and the issue isn't. You want to thank them, of course, for all their hard work. You want to empower them. I always tell them that deliberations coming up are the most important part of the case. They're the most important part, not me, not other stuff. And then I review with them the evidence on the standards, the evidence of what happened. The police practice experts, the family members, I get them, and then I go through the verdict form and some pertinent jury instructions with them. And I usually do it about 45 minutes, and it's very methodical, it's very persuasive, it's very good, fun to listen to, and I tell them why they should vote my way and what the damages should be. Okay, and I usually ask for a lot of money in damages. It seems like I'm asking more and more as I get older, and maybe that's because I'm getting more comfortable with it, or maybe it's because I'm getting bigger and bigger verdicts. But I maintain a certain level of respect. I don't lose it. I keep my composure. But I'm waiting for that rebuttal, Dan, because inevitably the other side gets up for an hour and they misrepresent the law, misrepresent the facts, are disrespectful to you, disrespectful to the decedent, disrespectful to your clients, and explain to the jury, they put the verdict form up there and they check the no boxes as if the jury doesn't know how to fill it out, telling them that's how they should vote. These people don't deserve a penny. It's all their fault, and we shouldn't even be here. And that's where I really get my juices going, and I come back hard in my rebuttal. I know some lawyers don't do much of a rebuttal, and most of the judges are going to limit your time, but my rebuttal is very passionate, very focused to show basically, from the line in My Cousin Vinny, everything that guy just said is bullshit. Of course, I don't say bullshit, but I am able to show in that rebuttal how they should vote in favor of the plaintiffs, and their case lacks total merit and total credibility. We shouldn't even be here, but we're here because they won't accept any responsibility.
But I want to talk to you about how you argue damages for this trial that we've been referring to. Because you're talking about a young man that has mental illness, so we don't have any probably economic losses. And so how did you come up with whatever you wanted to tell the jury the value of the case was? How did you come up with that number and deliver it and explain it and reason it with the jury?
So in this case, Dan, I had three elements of damages. One was the normal thing we think about, wrongful death damages. The mother lost her son. The loss of the love, companionship, support. I didn't have a wife. I didn't have young children who are very sympathetic. I just had the mom. I really focused on the testimony and the pictures in my closing. I brought him back to the words she said. I quoted or paraphrased her heartfelt words on the stand while showing beautiful pictures of her son with her. And in that case, it was 6 years since it happened. 6 years. And I said, she deserves a minimum of $1 million a year for the last 6 years of her life being without her son. Maybe more. And for the future, she deserves, I can't remember what I said, but I think I asked for something in the area of $12 million in wrongful death damages. So that was one element, past and future loss of her son. And of course, I got emotional and dramatic and explained, and sometimes I argue the golden rule without arguing it. Imagine losing a child. Imagine what it's like for a mother to raise a child, to live with the child, and then have the child killed. Even if it was a disease or accident, imagine how hard it would be. But if they're killed by the police, something so unnecessary and avoidable, then you have to live with that the rest of your life. Think about what you would look forward to with a son, getting married, having children, having grandchildren, having them there to take care of you when you get older. You really start making them think about their own families, right? And how valuable that is. And what's more valuable? What's more valuable than human life? And then the other two areas of damages I had were survival damages. So this is more particular. In 2013, there was a Ninth Circuit case that allowed for pre-death pain and suffering in these cases. A case called Chowdhury versus the City of Los Angeles. Now California state law, I believe as of 2022, allows pre-death pain and suffering. Other states do also. But the concern has been, well, how much are you going to get if the time between the incident and the death is short? The guy shot in the head and lives for 60 seconds. How much pre-death pain and suffering can you get? Now, in this case, I had the benefit of that extended video showing him dying. It's very powerful, even in the ambulance. So I've had great success in getting large pre-death pain and suffering verdicts, Dan. And I can't remember what I asked for, but I can tell you that I got 5 to 6 million in pre-death pain and suffering. And then I had my last category was loss of life damages. Now this is new. Most states do not have it. There was a case, a Ninth Circuit published opinion called Valenzuela v. City of Anaheim, where those damages were allowed and awarded by the jury, and the other side appealed, and the Ninth Circuit had to decide whether those should be damages that are allowable in these cases. The defense argued they're too intangible. What does that mean, the loss of your life, the value of your life? How is a jury ever going to calculate that? And that's not fair. It's not allowed under state law and should not be permitted. In a published opinion, which I'm proud of because it was my case and I did the oral argument, the Ninth Circuit said you get loss of life damages in these cases. So that was the other area that I argued, loss of life, the value of his life separate from the loss to the mother. He had his whole life ahead of him, and that has value. So ultimately, the jury awarded $12 million in wrongful death damages to the mother, which is one of the highest awards for one plaintiff in a death case for civil rights, and 11.8 million in survival damages, divided between pre-death pain and suffering and loss of life, for a total of 23.8 million. And I do believe it's one of the highest jury verdicts in the state and the country in that type of case, and maybe the highest survival damages. So the interesting thing, Dan, my last 3 trials of 8-figure verdicts, I've had 8 figures on just the survival damages in each case. So just the loss of life and pre-death pain and suffering, in all 3 cases, I got $10 million or more, which is now why these police departments are finally taking notice. They're finally paying on these claims. They're nervous about these jury awards. And I actually think they're finally starting to think we can't afford all of these shootings anymore. It's not that they really care that people are being killed. It's that they care that it's costing them too much money and too much public scrutiny. So I really feel, and I'm hopeful, because we haven't seen much deterrent in the last 10 or 20 years, that hitting them with these huge verdicts is finally getting them to take notice and to tell their cops on the field, look, don't be just shooting someone every time you feel a little bit afraid. It's costing us too much freaking money.
That's what it often comes down to. Even, these cops is the money. And, or it's experts, everybody, it's, we're in a money society.
Yeah, I think Chris Rock once said in one of his comedy skits, I'll tell you how to reduce police officer shootings. Start charging them $1 million per bullet. $1 million for every bullet they fire will come out of the budget of the police. I guarantee you we'll start having less shootings.
Well, Dale, so just so everybody knows this, that the Civil Rights Masterclass is June 7th and 8th. TLU Beach starts June 5th. So it's a 4-day event at the Paseo Hotel. We bought out the whole Paseo. And so it's going to be great because we do a full breakfast and a full lunch for everybody. We have theme parties every night with live music, food trucks, and of course, open bars. That the lobby of the Paseo is going to be a gaming lounge. We're going to have like a couple ping pong tables, air hockey, foosball, and a DJ every night. It's going to be the greatest trial lawyers event ever, Dale. And and there's so many people. I know you're part of the inner circle with my friends like Brian Panish and Lloyd Bell, and Ed Bell is coming from, I'm sure a friend of yours from South Carolina. Ben Rabinowitz was supposed to be coming, but he is on trial in a massive train derailment case. But local people from LA that are coming to teach are Nick Raleigh and Gary Dordick. Nick's going to be hosting 3 younger lawyers who got their first big verdicts, on Friday afternoon, the last hour. Then him and Gary are going to do 3 hours on Saturday morning. Mike Alder's teaching on depositions. I mean, it's Steve Vardazarian on voir dire. So lots of LA folks and people come from all over the country. Sean Claggett's doing 3 days with his firm, and, Satch Oliver and Dorothy Clay Sims on, the systems they have in place. Obviously, Panish and Rob Apudi, more of your inner circle friend. It's going to be I'm so psyched that you're coming, and people are going to learn so much here and make so many new friends and have a great time in Huntington Beach. So we're looking forward to that. And if you can't make Huntington Beach, we always got Vegas, because I look out my window every day at Caesar's Palace to get about October 16th through 19th, the Trial Lawyers Carnival. That one's going to be about 1,500 people, Dale. You came in 2022, right?
Yes, I did. And I want to say, Dan, and I've told you this before, both on air and off, I think you're doing amazing work. I think your events are incredible, and I really encourage people to come in person. I know a lot of people like to watch, and that's good too if you can't make it. But there's something about being there in person and meeting all the lawyers. And Dan has, as you know, some of the greatest trial lawyers, not only in California, but in the entire country. And these people are really good teachers, right? They're exciting and fun to listen to. The buzz is amazing. And Dan really does it up fun. I mean, he's got everything organized. So it's not only going to be great, you're going to learn a lot, you're going to meet a lot of new people and new lawyers, but you're going to have a lot of fun. and it's going to be great. And I'm really excited about it, Dan. And I think each time you do these events, quite frankly, they're getting better and better and better. And just when I think it can't get any better, the next one's even better than the last.
Well, wait till you see this one, because this one's going to have 4 lecture tracks and 9 workshop tracks. That's where your master class is one of those workshops. Because Vegas is going to have 8 lecture tracks and 20 workshop tracks. And so, it's going to be a little bigger, which is, some people are like, I don't like it so big. I'm like, but as long as it's, what I like about our conference is that there's so many selections every day of what people are going to learn. And people are in much smaller groups because it's not like we're shoving 800 people into one room and putting the speaker on a projector and everybody just sits there and listens, because it's very interactive. And when people are right where they want to be and are learning stuff that's important to them and their cases, I think it releases like endorphins in their brain, because they can see their cases now and they can see the value and how much better they could do in presenting their cases. And I think that's another thing that gets people really fired up, and also, it adds to having a great time. Is when you're having like breakthrough learning, that's fun. I mean, it's fun to socialize and have a drink, but it's not as much fun to come up with some brilliant ideas about our cases to make them better. That makes it more fun. Dale, if people want to get a hold of you for any reason, how's the best way to get a hold of you?
Probably my email, dalekgalipo@yahoo.com, or they can call the office at 818-347-3333. But we will respond to emails. I get a lot of emails from lawyers asking for my input or suggestion on an issue they might have, and we try our best to get back to everyone. That would be the best way, Dan.
All right. And let's see, if anybody can't make it, everything we've ever done, every live conference, all tracks, every masterclass, and every webinar has been recorded. And we try to gather the pleadings, transcripts, and PowerPoints for all of these presentations. So we have a virtual library of trial, which is called TLU On Demand. And it's also an app for your phone, so you can watch it anywhere, anytime, and always be learning, because there's so much to be learned. And that's to get you all the strategy. But if you ever really want to work on your physical skills of presentation, and like Dale said, it's about the connection, your ability to stand up and, be relaxed in front of all that pressure and to really connect. That's what we teach boot camps here once a month in Vegas, working on, they're 3.5 days, and people bring a case, so we're actually working on the case throughout the boot camp. And so therefore it's a very legitimate case cost, because you'll greatly improve the value of that case if you work on it for 3.5 days. And the better that we can tell the stories of our case, the more real they become to us, and the more authentically we communicate the story and the loss and the pain to those folks that we call jurors. And so, and we also teach these classes at the big events too. We have these breakout rooms where people get up and practice the physical skills of presentation and connection. So there's a lot going on here, Dale.
It's a lot going on.
You
know what I was
thinking? Of 2020 that you knew.
You know what I was thinking, Dan? Even if it helps you with one case that you currently have or are considering taking, it's well worth it. Well worth it, even if it's one case it helps you with.
Heck yeah. And like coming to like your, these master classes, like, Lloyd Bell's teaching a master class on medical malpractice. This guy, Michael Hill, all he does is elder abuse. And he has found ways to help juries see the value of these old and sick people who are dying, who have been abandoned by society and sometimes their family, but still to see the value of their human lives. And that's really amazing. I mean, impressive trial, advocacy is to see the value where nobody else can see it. And I say the beauty is that the people that are in these classes, they have their own like mastermind groups, basically, of like-minded people who are very committed to a particular area of law. And so now it's like this collaborative group that you have, not just for the 4 days, but really going forward, because you get to know all these people so well. And I ask everybody that's coming to the conference to write a personal bio, sharing the story of who they are written in the first person, so that can really help people to connect. Because, we know from the pandemic, the isolation that we suffered, how important our human connections are. And, especially with people who get us, because not many people really get what it's like to be a trial lawyer and have to put it all out there all the time. So that's just another value. So Dal, I really thank you for coming here. Oh, if anybody ever needs anything from me, let me tell you my phone number. My cell phone's 248-808 3130. My email is dan@triallawyersuniversity.com. Oh, that cross that I was demonstrating for Dale, it's also written as a defense medical expert cross. I was trying to change it just because it was for a cop there, but if anybody wants a copy of that cross, email me or text me and I'll be happy to shoot it out to you. And that's what I got for everybody. So thanks all for listening. I hope you got a lot out of it. I know I did. And thanks, Dale, for coming to visit. And I'll see you down in Huntington Beach because, we have themed parties every night too. So Thursday night, you want to be there because it's a pink and white Ken and Barbie party. Friday night's a Wild West party because we have live music, cocktails, and food trucks every night. And Saturday is Masters, the Masters, like golf, because like the Masters or the Masters, the Masters in Las Vegas, because Claggett's hosting a golf outing for 144 of his closest friends on October 16th at Valley High. So, got to kind of get people fired up for that is my thought process.
Oh, yes. Very exciting. Well, thank you very much for having me, Dan. Looking forward to seeing you in Huntington Beach.
Thanks, Dale. Take care. Bye-bye. Thanks, everybody.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.